Hello, everyone. Today we're going to talk about tort liability. It's a big term and it's extremely important that you are familiar with a lot of the vocabulary that I'm going to present to you. So let's get started. All right, so what is tort liability? Tort law is based on the legal premise that individuals are liable for the consequences of their own conduct or lack of conduct when such actions result in injury to others. In the school classroom setting, tort law is the most common area of the law that subjects teachers to personal liability. Okay, so that's why we're going to be talking about it, because it is the most common within classrooms and school settings. Black's Law Dictionary defines a tort as a civil wrong for which a remedy may be obtained, usually in the form of damages. Tort claims in the context of schools and agencies are based on the premise that an employee is liable for the consequences of his or her conduct if it results in injury to a child. The majority of child injury lawsuits involve claims of negligence. We're going to continue talking about torts in the educational setting and the four most common that we find at schools. So the first one is assault. And this would be giving someone the reasonable belief that you are about to be touched. Okay, so sometimes it's not actually carrying it out, it's just making them believe that it's kind of a threat type scenario where you make them believe that you are about to touch them or hurt them in some way. Battery is an intentional infliction of harmful or offensive contact. False imprisonment is an intentional confinement by direct physical means, threats, or assertion of legal authority if the act of confinement causes physical or mental stress. So this does not include, like, if you were to send a child to the office or anything like that. It's more in regards to like tying a child up to a chair or putting them in a small room where it might be mentally stressful for them. And then defamation is like a false statement that tends to harm another person's reputation, exposing them to hatred, shame, disgrace, contempt, or ridicule. And that's one that I didn't necessarily think that was going to be put on. It just didn't cross my mind of, like talking about a child maybe in front of other children where you are hurting their reputation or causing shame. So that's something that I broadened my belief of what a tort could be. So things to consider as you're looking at all four of these categories would be the age of a child. So fifth grade children's obviously going to be a little bit different than a kindergartner. Disciplinary instrument that's used. So if you used something or if another child used something to an object of any sort. The gravity of the student offense, and the discipline history of that student. All right, so some of the terms that I felt were important for us to talk about is contributory negligence. So if the court holds the contributory negligence was a factor in the child's injury, the school or agency may be held only partially liable or not liable at all, depending on the jurisdiction. It is difficult to prove contributory negligence against children under the age of 7 because tort laws generally hold that young children are incapable of contributory to their own negligence at that age. Okay, another one would be the reasonable standard of care. So you should consider the following. So like proper employee training or lack thereof, the age of the child, the type of activity, was the employee present, and the environment of which the injury occurred. An actual injury is the injury does not have to be physical, which is something important to remember, that it can be emotional, but it must be documented and sustainable. And then proximate cause depends on establishing that a child's injury could have been foreseen or prevented. All right, so now I have some examples of things that have happened at schools, and then kind of how it came out throughout the court system. So Mitchell versus Cedar Rapids Community School District. So this was a teenage student, and this student had permission to go home with another student after school. The student ended up skipping the last period, but the school failed to report that she was not there at school to the parents. And then later on, after school hours, the teenager student was raped. So her mother sued the school for negligence, and because they were failing to monitor the child and then to notify the parents in a timely manner. So the school argued that the incident happened outside of school, in a different location, and outside of operating hours. However, the Iowa Supreme Court ruled that the incident could have been prevented. So the reason that this one came back and the school was held liable was because they did not carry through and follow the protocol of calling the parents and letting them know that she was not present. Okay, the next one is Kowalski versus the Berkeley County Schools. This student created a MySpace account, and the purpose of that was to cyberbully another student, so ridicule another student. And then a lot of students joined this account and participated in the cyberbullying. So the victim and the parents filed harassment complaint with the school. But then what's interesting is the website creator was suspended for 5 days and didn't like that. So then the website creator ended up suing, claiming that her First Amendment rights were violated. She felt that she had the right to create an account and exercise her First Amendment rights of freedom of speech. However, the court ruled that the site's content interfered with the school environment. It stated that the school is obligated to protect students from all forms of bullying, and this allows schools to control, to some certain extent, the student's speech. So anytime that it then, even if it's happening outside of school, if it's affecting the safety and the continuation of education in the school, then that's kind of the tricky spot. And that's why the website creator was found that that's just the way it was, and she didn't get her way. Wyke versus Polk County School Board. So this 13-year-old committed suicide at home, and the mother sued the school district. But what's important to understand is what happened leading up to this. So previously, the student was called into the office after his first attempt. The school had found out that he had attempted it, and the dean of students ended up reading some Bible verses with the student. And then there was another separate account when the student was in the bathroom and a custodian walked in, and the boy made the comment that he was about to commit suicide. Now, the mother sued the school for inadequate intervention and the preventing training for the school employees that ended up contributing to her son's wrongful death. The school was found liable due to the failure of notifying the boy's family of their knowledge of his 2 attempts. So again, not following through on the protocol and not notifying and keeping in contact with the parents on those very serious, him having that first attempt and then making that comment, those parents should have been notified. The next one is Myers versus Cincinnati Board of Education. So this one I really was kind of shocked. I think it's important for you to understand that this is a 3rd grade boy. 3rd grade. He was knocked unconscious by another boy in the bathroom, and he laid on the bathroom floor unconscious for at least 7 more minutes. And during those 7 minutes, other children were kicking him and hurting him. Now, it also is important to understand that he does not remember this happening to him. I will say, though, that the school was aware of it happening. So once an adult showed up to the bathroom, they disregarded the safety protocol, and the staff members took him to the nurse's office. An hour later, the staff did call the parents, but reported that he had fainted and that there was no need for further medical attention. So they did not at all talk about the event of being hit and kicked repeatedly. The next day, the boy did not feel well. His mother took him to the doctor, but they did not check for head injuries because he had no memory of the incident the day before, and the parent did not know about those injuries before. The boy returned to school that afternoon, and that afternoon he was subjected to further bullying. He committed suicide that evening. Again, that was a third grade boy. So, how do we avoid getting caught up in tort liability? And more importantly, not just covering our own lives and our own jobs, but how do we keep this from happening to children? So, having clear and strong policies and administrative procedures, adequate staff and student training, a quick response to any observed or reported violation of a student's right, and taking a hard look at the school culture will help to protect a school from costly litigation and promote the well-being of all children and staff, which in my opinion is more important. Other things that I think that we definitely need to talk about is how to avoid this. So perform your duties. You know, we are all, I feel like our school does a very good job of having protocols and procedures in place, but it's essentially up to us to perform our duties and to follow those things that are there for us. Provide appropriate instructions. So not only explicitly teaching the expectations and the rules in our school, but reviewing those on a regular basis, not only for us, but for our students. They need to be very aware of what's expected of them. Again, adhering to school policies and procedures. Don't make up your own. Okay, I am definitely guilty of this at recess. You know, we have a set policies and procedures for, rules and guidelines for the playground. And oftentimes, if you don't agree with one of those, you kind of make up your own while you're out there. And that's just really not going to keep children safe. It's going to cause confusion. So make sure that we are not making up our own, that we are agreeing as a staff and we have complete buy-in that those are our school policies and procedures. And then the next one is keep private information private as it's supposed to be. So those are 4 things that are just really easy for us to jot down if we need to. Make sure we're doing those 4 things, and we should be pretty well protected. If you would like more information, I have the references cited here. They are active links, and these will be provided within our OneNote folder. So you are able to access those whenever you need them. I encourage you to do that. Thank you for listening. Bye-bye.